Welcome back to the Deep Dive. Today, we're getting into something really fundamental in criminal law. It's all about how what someone does matches up with what they were actually thinking at the time.
Exactly. We're looking at that crucial connection, the timing and the focus, between actions and mental states. Because liability isn't automatic.
Right. The law basically asks two things, doesn't it?
Hmm.
There's the actus reus, that's the guilty act, the physical things someone does or sometimes doesn't do.
The external element. And then there's the mens rea, the guilty mind. That's the internal bit, like intention or knowing something or being reckless.
And the core idea we're diving into today is that, well, in principle at least, these two things, the actus reus and the mens rea, they have to happen at the same time. They need to coincide.
That's the general rule. Coincidence.
Yeah.
And it has two main facets we need to unpack. First, there's temporal coincidence, basically the timing.
Did the thought and the act happen together?
Pretty much, yeah. Did you have the required mens rea at the exact moment you did the actus reus? And second, there's something called the correspondence principle.
Okay, what's that about?
Well, that's more about the scope. Does the mental state you had actually match up with all the different parts of the physical act the law cares about?
Gotcha. Okay, so timing and matching. And just before we jump in, we should say this deep dive is based on some fantastic educational materials made available by the University of London.
That's right, and we're bringing this to you through Sinorbit Academy, Sri Lanka.
So for all of you listening who might be using these materials for your studies, we really hope this helps make things a bit clearer. And genuinely, good luck with those exams.
Okay, let's start with temporal coincidence, the timing thing. It sounds simple enough the defendant needs the mens rea right when they're doing the actus reus.
Right. Let's use that wallet example. Illustration 6.1 from the material. So someone, let's call them D, sees a wallet, kicks it up. At that moment, they fully intend to steal it.
Clearance.
But then, like, instantly, they regret it, feel bad, change their mind, and put the wallet right back down.
Okay. Now, common sense probably tells you, well, they put it back, no harm really done, changed their mind, surely not guilty.
Yeah, that feels fair. They stopped themselves. But what's the strict legal answer, focusing on that temporal coincidence?
The legal answer, based on the definition of theft, is probably guilty. Theft, roughly, is appropriating property belonging to another with the intention to permanently deprive.
Okay.
The key is the appropriation. That happens the moment D takes the wallet. And at that exact moment, D did have the intention to permanently deprive. The actus reus taking the wallet coincided perfectly with the mens rea, the intention to steal.
Wow. So even though they immediately changed their mind, the crime was technically complete in that split second.
Legally, yes. The later change of heart doesn't undo the crime that was completed when the act and intent coincided. It really shows how precise this timing requirement can be.
It really does. And this isn't just theoretical, right? It affects real cases.
Absolutely. Look at a mod from 1986. This involved a landlord charged with harassing a tenant, specifically with the intent to make them leave their home.
Okay, and the actus reus, the physical act.
The landlord had removed windows from the tenant's property, which, sounds pretty harassing.
Yeah, definitely. So guilty.
Actually, no, not guilty of that specific offense. The court found that the landlord's intent to harass and drive the tenant out was formed only after he'd already finished removing the windows.
So he took the windows out, then decided that was a good way to get the tenant to leave. The actus reus happened first, then the mens rea followed later.
Exactly. The physical act was complete before the required mental state existed. Because they didn't coincide in time, no temporal coincidence, the charge failed.
That feels tricky. He did the act, he had the bad thought eventually, but the timing was off.
That's the power of the temporal coincidence rule. It can feel a bit counterintuitive sometimes.
Which makes that thinking prompt, activity 6.1, really interesting. You've got a contract killer driving to the victim's house. On the way, they accidentally hit and kill a pedestrian. Turns out, the pedestrian is the intended victim, V. The killer gets out, sees it's V, and is actually pleased. Job done accidentally.
Right. So the question is the killer guilty of murder? Apply the temporal coincidence rule strictly.
Well, the intent to kill V was definitely there. And the killer's action, the driving, did cause V's death. But did the intent to kill exist at the exact moment of the accidental driving that caused the death?
That's the problem, isn't it? At the moment of the collision, the killer's intent was probably just focused on, well, driving or maybe anticipating the later killing at the house. not on causing that specific accident.
So the intent and the fatal act didn't quite line up in that instant, even
Uh-huh.
though the end result was what they wanted.
It shows just how crucial the precise connection is. But, the law isn't completely inflexible. Sometimes applying this rule super strictly feels wrong, like it lets people off who are clearly blameworthy.
So there are ways around it.
Well, not exactly exceptions where you don't need coincidence, but more like ways the courts interpret the situation differently to find coincidence. Clever ways of looking at the timeline or the act itself.
Okay, what are these methods?
One is finding liability based on a later omission, a failure to act. The classic case here is Miller, 1983. Remember this one?
Vaguely. The squatter and the mattress fire.
That's the one. Miller, a squatter, fell asleep while smoking. His cigarette started a fire in the mattress. Now, the act of starting the fire, he was asleep. No mens rea then, obviously.
Right, unconscious. So under strict temporal coincidence for the act of setting the fire, he can't be guilty of arson for that moment.
Correct. But what happened next is key. Miller woke up, saw the mattress smoldering, and what did he do?
Didn't he just move to another room?
Exactly. He did nothing to put out the fire or call for help. The House of Lords said by accidentally creating that dangerous situation. Once he became aware of it, he had a duty to take reasonable steps to deal with it.
Oh.
His failure to act his omission happened when he was aware of the danger and simply ignored it. So, his reckless omission, the actus reus, viewed as the failure to act, coincided with his recklessness, the mens rea being aware of the risk and doing nothing.
So they pin the liability not on the accidental starting of the fire, but on the later failure to act when he knew about it.
Precisely. They grafted the liability onto the subsequent omission, which did coincide with the necessary mens rea.
Clever. Okay, what's the other method?
It's called the continuing act doctrine. This came up in a really famous case, Fagan v. MPC, 1969.
Oh, the car on the policeman's foot. I remember this one.
That's it. Fagan accidentally drove his car onto a police officer's foot. I didn't realize it first.
So the initial act of driving onto the foot, no intent to apply force then?
Yeah.
Accidental. No mens rea for assault at that point.
Right. But then the officer told him, get off my foot. Fagan knew the car was there and, well, he deliberately refused to move it for a bit. Now he has the intent to apply unlawful force.
Okay, so the mens rea for assault forms while the car is already on the foot. But the defense argued assault needs an act, not just sitting there doing nothing in omission. When the intent was formed, there was no new act happening.
Exactly the problem. Seems like no temporal coincidence again. But the court said, wait a minute, the act of having the car on the foot wasn't just instantaneous, it was a continuing act. It started accidentally, but it continued while Fagan knew about it and formed the intent.
So the act was ongoing, and the intent arose during that ongoing act.
That was the court's reasoning. The mens rea was superimposed onto the existing, continuing actus reus. So coincidence was satisfied. It stretches the definition of act a bit, maybe, but it achieved the result.
It does feel like a bit of legal maneuvering, treating staying still as an act, but I see how it gets around the timing problem. It kind of links to other cases too, doesn't it? Like Santana Bermudez.
Yes, the needle case. Failing to warn the officer, was that an omission or part of a broader course of conduct creating danger? These cases explore that blurry line. So Miller and Fagan show courts finding coincidence by looking at omissions or continuing acts.
Okay, but you mentioned earlier there might be a situation that is more like a real exception, where the rule genuinely seems bent or set aside.
Yeah.
The supposed corpse cases.
Yes, these are quite dramatic and frankly pretty grim scenarios. They involve a specific sequence, D attacks V, intending to kill or cause serious harm.
Okay.
Then D mistakenly believes V is already dead because of the attack. And then D does something else, usually trying to dispose of the body, like throwing it in a river or rolling it off a cliff.
Right.
But the twist is, V wasn't actually dead from the initial attack. V dies as a result of the second act, the disposal.
Okay, so the intent to kill was there during the first attack, but the act that actually caused death happened later when D thought V was already dead, meaning no intent at that fatal moment.
Precisely. On a strict temporal coincidence analysis, it looks like there's no mens rea for murder coinciding with the actus reus that caused death.
So how do the courts deal with this? Surely they don't just let people off.
No, they don't. The key early case showing the approach is Melly v. the Queen from 1954. This involved a prearranged plan. The defendants lured the victim, beat him up, intending to kill him. They thought he was dead. Then, according to their plan, they rolled his body over a cliff to make it look like an accident. But the medical evidence showed he died from exposure at the bottom of the cliff hours later, not from the initial beating.
So the defense argument must have been the act causing death, rolling him off the cliff, lacked mens rea because we thought he was already dead. No temporal coincidence.
That was the argument. But the Privy Council absolutely rejected it. Lord Reed famously said it was impossible to divide up what was really one transaction.
One transaction.
Yes. The court viewed the entire sequence, the plan, the initial attack with intent, the disposal as a single indivisible series of acts aimed at causing death. Because the mens rea existed at the beginning of this transaction, it was held to cover the fatal consequence at the end, even if there was a mistake about the exact moment of death within that plan. Lord Reed felt it was much too refined an argument to let them escape liability based on that mistake.
So if it's all part of one overarching plan or transaction to cause death, the initial intent carries through, even if it wasn't present at the very final fatal step.
That's the Melly approach, especially strong where there's a preconceived plan. But what if there's no plan? Like in Church, 1966.
Okay, what happened in Church?
D got into a fight with V, struck her, and she collapsed, appearing lifeless. D panicked. Thinking she was dead, he threw her body into a nearby river. She actually died from drowning.
So similar situation, intent during the initial strike, but the fatal act, throwing her in the river, done under the mistaken belief she was dead. No plan here, just panic.
Exactly. The court in Church didn't focus so much on one transaction. Instead, they talked about the chain of causation. Edmund Davies J. said liability for homicide could arise if the whole course of conduct, from the moment he first struck her to the moment when he threw her into the river, could be seen as a series of acts designed to cause death or grievous bodily harm.
So the initial unlawful act, the strike with mens rea, started a chain of events. And the later act, throwing her in the river, even done mistakenly, didn't break that chain leading to her death.
That's the idea. The later act was still causally linked to the initial culpable assault. It wasn't seen as a completely separate intervening event.
So Melly uses one transaction, Church uses chain of causation. Different emphasis, same result.
Pretty much. They both find ways to hold the defendant liable despite the apparent lack of strict temporal coincidence for the final act. And this causation idea was developed further in Lebrun in 1992.
Okay, Lebrun, what were the facts there?
D argued with his wife, struck her unlawfully, causing her to fall and hit her head, knocking her unconscious. He didn't think she was dead, just knocked out. He then tried to drag her body to conceal the assault. Tragically, she died from injuries she sustained during the dragging, not from the initial blow or the fall.
Oh, wow. So the initial unlawful act, the blow, had mens rea, but wasn't fatal. The later act, dragging, was fatal, but maybe the intent then was just to hide her, not to kill her.
That was the potential issue. Lord Lane, for the Court of Appeal, tackled this head-on using causation. He said the initial unlawful blow was definitely a but-for cause, the causa sine qua non. Crucially, he argued the subsequent act of dragging, done specifically to cover up the initial assault, did not break the chain of causation flowing from that first unlawful act.
So the cover-up attempt linked the final fatal act back to the initial crime.
Yes, and Lord Lane explicitly stated that in these kinds of circumstances, the act which causes death and the necessary mental state need not coincide in point of time. The key idea from Lebrun is that if the later act causing death is done as part of the same sequence, or to conceal the initial unlawful act, which did have the required mens rea, then strict temporal coincidence isn't necessary.
That's a really significant statement. It seems these supposed corpse cases really are treated differently, using one transaction or causal chain logic to bridge the time gap between the initial intent and the final fatal act. That makes sense of Activity 6.32, asking if the defendant's intention during the disposal matters. Lebrun suggests if that intention is about covering up the first crime, it actually strengthens the link rather than breaking it.
Exactly. The intention during the disposal isn't providing the mens rea for the death itself, but it's showing that the disposal wasn't some independent act, but was intrinsically linked back to the original culpable conduct.
Okay, that clarifies the timing aspect and its complications. Let's switch gears now to the other principle you mentioned, the correspondence principle. This isn't about when things happen, but what needs to match up.
Correct. The correspondence principle is about the scope of the mens rea. Ideally, it says the defendant's mental state, their intent, knowledge, recklessness should correspond to or cover every single element of the actus reus. That means the conduct, any relevant circumstances, and any consequence specified in the crime's definition.
And what's the thinking behind this principle? Why is it seen as important?
It's rooted in fairness, really. The idea of just deserts. If you're going to be convicted and punished for causing a particular result or for acting under particular circumstances, The argument is you should have had the required mental attitude towards that specific result or circumstance. Punishing someone for X when they didn't even intend, know about, or foresee X feels instinctively unfair to many.
Okay, let's use theft again. Illustration 6.2. Remind us of the actus reus.
Appropriating property belonging to another with the intention of permanently depriving them of it.
So, applying the correspondence principle, what mens rea elements do we need?
Well, you need the intention to conduct the appropriation, and you also need a mental state regarding the circumstance that the property belongs to another. For theft, the law generally requires that you know or believe it belongs to someone else.
Right, so if I grab an umbrella from a stand, genuinely believing it's mine because it looks identical, I haven't committed theft, even though I appropriated property belonging to another. Why?
Because your mens rea didn't correspond to the actus reus element belonging to another. You didn't know or believe it was someone else's. The mental state didn't cover that crucial circumstance.
Got it. So that applies to circumstances. What about the prompt in activity 6.4? An offense of having sex with someone who lacks mental capacity.
Yep.
What mental state would correspondence demand regarding the victim's capacity?
Ideally, the correspondence principle would suggest the prosecution should have to prove the defendant knew the victim lacked capacity, or was at least reckless as to whether they did. The mens rea, knowledge or recklessness, should correspond directly to that specific circumstance element of the actus reus, the victim's lack of capacity.
Okay, so the mind has to be aware of or culpable towards each key part of the act. But you said this is an ideal.
Yes, it's important to stress that. The correspondence principle is a guiding principle, a normative standard, but it's definitely not strictly followed in every area of English criminal law. Many crimes, including very serious ones, actually breach it.
How? Can you give an example?
Murder is the classic example. The actus reus of murder is causing death. Simple enough.
Right.
But what's the mens rea for murder? It's intent to kill or intent to cause grievous bodily harm, GBH, really serious injury.
Ah, I see the mismatch straight away. The actus reus consequence is death, but the mens rea might only be an intent for serious harm, not necessarily death itself.
Exactly. That's a clear breach of the correspondence principle regarding the consequence element. You can be guilty of murder even if you only intended serious harm, provided that harm caused death.
That activity 6.5 prompt touches on this, doesn't it? If A deliberately breaks V's legs, intending serious harm, and V later falls while trying to get up on crutches, hits their head and dies, is A guilty of murder?
Well, potentially yes, subject to causation rules. A had the mens rea for murder, intent to cause GBH, and the actus reus occurred. V died as a result, arguably, of the initial attack. But the mens rea didn't perfectly correspond to the result of death. The law allows this breach. Thinkers like Professor Horder have written about the justifications, basically arguing that someone who intends really serious harm is sufficiently culpable to bear responsibility if death results.
So the law sometimes decides that intending a certain level of harm is bad enough to hold you responsible for an even worse outcome, even if you didn't specifically intend that outcome.
In certain contexts, yes. And closely related to this, but slightly different, is a major qualification to the correspondence principle. The doctrine of transferred malice, sometimes called transferred intent.
Okay, transferred malice, what does this do?
It basically stops a defendant wriggling out of liability just because their bad aim meant they harmed victim Y when they were trying to harm victim X.
Right, the classic scenario from illustration 6.3, D aims a gun at B, intending to kill. D fires, misses B, but the bullet hits and kills C, an innocent bystander.
What happens to D? Under transferred malice, the law effectively transfers D's intention to kill B over to the actual victim. CD had the mens rea for murder, intent to kill, and performed the actus reus of murder, causing C's death. The doctrine connects the two.
So the malice follows the bullet, so to speak.
That's a good way to put it. Lord Mustill, in AG's Ref. Nully 3 of 1994, explained it elegantly. He said the doctrine treats the intended victim and the actual victim as if they were one, combining the intended result for B with the actual result for C to satisfy the crime's definition. D would likely also be guilty of attempting to murder B. By the way, that came up in R.V. Nongo.
And this isn't limited to murder, is it?
No, definitely not. It applies widely, especially in offenses against the person. The old case of Latimer, 1886, is a perfect example. D got into an argument in a pub, took off his belt, and swung it at man X.
Okay.
He missed X, but the belt recoiled and struck woman V standing nearby, injuring her. He was charged with unlawful wounding against V.
Even though he intended to hit X?
Yes. The court held his intent to hit X, his malice, could be transferred to the actual striking of V. So he was guilty of the offense against V.
Okay. What if the type of harm is different? Say you intend to kill someone, but only manage to wound the bystander.
That issue came up in R.V. Grant in 2014. D fired shots into a shop, clearly intending to kill someone inside X. He missed X, but hit two other people, V1 and V2, causing them GBH.
Okay. So intent to kill X resulted in GBH to V1 and V2? What was the argument?
The defense argued, wait, the intent was to kill X. That specific intent can't be transferred to make him guilty of intending GBH to V1 and V2 because he didn't intend GBH towards X.
That sounds logical in a way. Did it work?
No, the court rejected it. They reasoned that if you intend to kill someone, you must, by definition, also intend to cause them at least GBH. It's inherent in the intent to kill.
Ah, so the greater intent to kill automatically includes the lesser intent to cause GBH.
That was the court's view. So that lesser intent to cause GBH could then be transferred to the actual victims, V1 and V2, who suffered GBH.
Okay, that makes sense. So transferred malice seems quite broad. Are there any limits?
Yes, a very important one. Transferred malice only works if the crime you intended to commit and the crime you actually committed are of the same type or, as it's often put, the same family of offenses.
Same family. What does that mean in practice?
The crucial case here is Pembleton, way back in 1874. D got into a fight outside a pub and threw a large stone at the people he was fighting with. Let's call them X.
Okay, intent to hit a person.
But he missed them completely. The stone flew past and smashed a nearby pub window. He was charged with criminal damage to the window.
So intent to assault X resulted in criminal damage to the window. Can the intent transfer?
The court said absolutely not. Lord Blackburn was very clear. You cannot transfer malice from an intended offense against a person, like assault or GBH, to an actual offense against property, like criminal damage. They are different families of crime.
Ah, okay, so person-to-person transfers work. Property to property probably works, but you can't transfer intent from a person to property, or presumably vice versa.
That's the rule from Pembleton. The mens rea for harming people doesn't magically become the mens rea for damaging things. D would only be guilty of criminal damage if he separately intended or was reckless as to breaking the window itself.
That really clarifies the boundary.
Yeah.
Those activity 6.6 prompts make sense now. If you shoot at B intending to kill, the bullet ricochets and wounds. C, the intent can transfer because murder and wounding are both crimes against the person, same family. But if you shoot at B's car, intending criminal damage, and the bullet kills C's dog, maybe no transferred malice for criminal damage to the dog because the initial intent was towards inanimate property and the result was harm to an animal, potentially different families.
That's exactly the kind of analysis Pembleton requires you to do. Is the harm intended and the harm caused fundamentally of the same type? Transferred malice is a powerful tool, but it respects these basic categories of crime.
Right, so it stops people escaping on a fluke of bad aim, but it doesn't just map any bad intention onto any bad result.
Precisely put.
Okay, wow. We've covered a lot of ground there. Let's try and quickly recap the main points.
Yeah.
We started with that fundamental idea. For criminal liability, you generally need the actus reus and the mens rea to coincide.
Yep. And we looked first at temporal coincidence, the timing, the mind and act needing to happen together. We saw how cases like Ahmad show this matter's intent after the act wasn't enough.
But we also saw how the law can sometimes, well, find coincidence where it looks tricky, using ideas like liability for an omission after creating danger, like in Miller.
Or by viewing the situation as a continuing act, like the car on the foot in Fagan. These aren't really exceptions, but ways of interpreting the actus reus to align with the mens rea.
Then we hit the supposed corpse cases, Melly, Church, Lebrun. These seem like a more genuine departure from strict timing for the fatal act.
Right, using concepts like one transaction or chain of causation to link the initial intent during the first attack to the eventual death caused by the disposal, even with the mistake about whether the victim was already dead.
And then we shifted to the correspondence principle, the idea that the mens rea should ideally match each part of the actus reus: conduct, circumstances, consequences.
We used theft to show how you need the mental state for belonging to another, but we also noted it's an ideal, often breached, like in murder, where intent for GBH suffices for the actus reus of causing death.
Finally, we explored transferred malice, how intent aimed at one target can be transferred to the actual victim, Latimer, Grant, fixing the correspondence problem in those cases.
But only crucially, if the intended crime and the actual crime are in the same family of offenses. You can't transfer intent to harm a person to damage property, as Pembleton showed us.
These distinctions, temporal coincidence, continuing acts, omissions, causation, correspondence, transferred malice, they might seem really technical. Why is it so important for the law and for students to grasp them?
Because these are the tools the legal system uses to decide if someone is truly responsible for a crime. Real life is messy. Intentions and actions don't always line up perfectly. These principles help courts analyze that messiness against the specific definitions of crimes. They're trying to ensure that we only hold people criminally liable when their conduct and their state of mind combine in a way the law considers blameworthy. It's about fairness, about ensuring punishment is deserved according to legal standards while still achieving justice.
It's that constant balancing act, isn't it, between the complexity of human behavior and the need for clear legal rules. A really crucial challenge. Well, that brings us to the end of this deep dive on the coincidence of actus reus and mens rea.
We really hope digging into these principles and cases has been helpful. And again, for everyone studying this complex area using the University of London materials, keep going, analyze carefully, and very best of luck with your exams.
Absolutely. This deep dive was based on those excellent educational materials from the University of London, brought to you by Sinorbit Academy, Sri Lanka. Keep thinking, keep questioning, and join us next time on the deep dive.